Okay, well, welcome back. While we're on break with the McStay case, I got a new guest we're going to bring on right now, and we also have some more testimony we can go over because we've culled out the most important testimony of this case. We just got done listening to the prosecution defense openings, both sides doing a tremendous job. So, Brian Buckmire from the New York City Public Defender's Office. Wow, wow, wow. You do what we would call in Jersey when we refer to public defenders, God's work, Brian. So welcome to the show.
Thank you for having me.
Yeah, it's great having you. So I hear that you've moved yourself in a stellar career trying cases and being successful up to and including attempted murder cases, and you're getting ready to start some murder cases. So you've moved pretty quickly through that office. Congratulations to you on that.
Thank you. I've been very fortunate enough to try enough cases that my office has given me the security to work on murder cases as a second seat, so someone more senior. And then I'm starting to try attempted murder cases on my own, or at least have them as a caseload.
Yeah, that's great. You know, I used to say to people, Brian, that when you're looking for a lawyer, don't just go with somebody who says they were with a prosecutor's office or a public defender's office. Ask them if they've ever been given an attempted murder or a murder case or a rape case, because your bosses only give the A-team those kind of cases, because those aren't cases to lose. So I know you're lighting it up there. Good for you. Congratulations.
Thank you very much.
So listen, in this case, it's unbelievable because these lawyers have done a great job on both sides. Of course, the prosecution has approved the case to 12 people beyond a reasonable doubt. You were listening to some of the opening statements. I mean, they're both out there. As you said before when we were not on camera, it's more than just an opening for the defense attorney. I think you'd agree with me. If you have an opportunity to strike blood in the beginning of the case as a defense lawyer, you do it, right?
Absolutely. Sometimes we refer to it as a non-opening opening, where you just come up and you say, hey, the prosecutor's got to prove their case beyond a reasonable doubt. Please listen to all the facts, and we'll come back to a summation. But on this one, the defense attorney is really going after it. What we'd say is we're going after recency, primacy, and frequency. Mm-hmm. We're telling it to them early. We're telling it to them first. We're telling them as often as possible why this case will not be proven.
Yeah, and I talk when I train trial lawyers, and I know my friend Gene Rossi we had on there. He's trained many himself. We always say that you need to say something substantive. They need to walk away with a question mark in their head. So Brian, listen, we also had some really compelling and interesting testimony here from a forensic expert that talked about all of the bones that were there, was at the scene. Alexis Gray was her name. And I think that is very powerful testimony for the prosecution because it's a really brutal case. An entire family has been eliminated. The prosecutor did a great job of bringing out all the blunt force trauma and the brutality of the case, as did this forensic anthropologist. But it's still a question of who did it. But let's take a look at her testimony, and I'll come back and discuss it with you on the other end.
Remains which then to go forward, and then I had seen some remains sticking out that I thought probably indicated a fourth.
Okay. You indicated that you saw some remains sticking out. Do you recall whether they were sticking out of grave A or grave B?
Well, you would have to tell me which one we designated as grade A or grade B. I don't remember.
So if the one in front of you, if we looked at that and said that's grade B.
Okay, grade B. Then it would be grade A.
Now, when you do this quick canvass, how worried are you about contaminating anything around you in terms of potential evidence?
Moderately. I mean, we have to weigh our need to get over a large distance versus preserving absolutely everything. In the desert, that's not possible anymore. So many factors have come in, from animals to weather to other people, coming through and all of that. The idea that you would have a pristine scene is something that you have to discard very early on.
Well, as you're walking around that day, can you tell us, you indicated that you saw tire tracks leading up to this particular grave that we see in the picture. Did you see other things indicative of animal activity?
Yes.
Did you see other tracks or things of indicative of maybe people riding dirt bikes or driving through there?
Yes.
Did you see other things indicative of footprints or anything like that?
I don't think I saw anything in terms of footprints. There was general cultural debris. Anytime you're out in the desert, there are cans and shotgun shells and all of this unrelated material that you kind of keep an eye on in case it turns out to be related, but most of the time you kind of walk past it, skirt it.
So as you go to this scene and you ultimately do this quick canvass, you indicated you are not dealing with a pristine crime scene at this point.
That is correct.
So if this is not a pristine crime scene, when you're walking around observing this, are you picking up items?
No, occasionally I'll pick up animal remains because I want to get them out of the field of play, if you will.
Okay.
And every once in a while you flip it over and make sure that you absolutely have an animal as opposed to some very unusual human.
Okay. I'm sure you've seen some unusual things.
I have.
Okay. So you determined that you're dealing with at least 2 adults and a child, and potentially another victim because you see something sticking out of the other grave, which we'll for now call grave A. What do you and Deputy Avery decide to do?
I asked him to call it in, and we asked for a deputy who can stand watch over the area until a recovery can be mounted the next day, because it was winter, and I think by the time we found the second grave, it was later. It was past 1, past 2, and you certainly couldn't mount something that large before it got dark.
You know, that's my fault. I didn't ask you that question. Do you know approximately what time it was that you responded to the scene that day?
No.
Okay.
I want to say 11. It could have been 1. It was around lunchtime.
Okay. So you...
Okay, so there's the forensic anthropologist, Brian. Just to add to her testimony, she talked about there were animals out in the desert. This is a witness call by the prosecution that it's not a quote-unquote pristine crime scene. I'm not even really sure, Brian, in all the years I've done murder cases on both sides of the aisle, I've ever seen a quote-unquote pristine crime scene, whatever that means. But that DNA was not practical to get in this particular case. I mentioned this to you for one reason. One, they got DNA from items that potentially could have been from the perpetrator, and it did not come back to any of the victims or the defendant in the case. So as a prosecutor to say it's not practicable when your people, your crime scene investigators actually did it and got it, to me is somewhat of a disingenuous argument. I know she's got to get around the problem, but I wouldn't do it that way necessarily. And in addition to that, this woman clearly indicated she's not even an expert in DNA. She went to a couple of classes. The defense tried to object. The judge at some point, not in this clip, but another clip, said, no, sit down. He didn't even get to make a record. What do you make of all this? I mean, I think that as a defense lawyer, you could really rail that home in summation, no?
Absolutely. I think what the prosecutor is attempting to do is try to pull a bit of the sting out of what the defense attorney is eventually going to do. That being that it's not a pristine situation. We don't know where this came from or that came from. There's animals, there's coyotes coming through. But I think the prosecutor might have gone a little bit too much into it. That kind of gives the defense attorney a little bit too much to grab onto when he gets into summation. As to your second point, when you mention how they're kind of evaluating the scene and the lack of DNA, that's very strange to me how the judge would not allow them to leave that out, because they are obviously coming as a expert on forensic anthropology. Why then can you bleed into DNA? That is simply just adding to the confusion for the jury, and I don't want them convicting based on something that they're not an expert on.
Yeah, I was saying to my previous guest that you basically had the only witness I've ever seen in my career that was specifically non-qualified in a particular area, therefore not an expert, asked to give an expert opinion about the very thing that she was non-qualified for. And I have a problem. I'm just curious as to what you think about this as a defense lawyer. Tactically, the judge is not allowing them to go to make a record. We know that this case may, if there's a conviction, go on appeal. As a defense lawyer, do you lay back and say to the appellate division, if there's a conviction, hey, the judge will not let me make a record, what can I say? Does that help the defense more, or do you fight to say, Judge, I need to get this on the record, even if it's writing a letter afterwards to the court to say why you wanted to introduce something?
No, you fight. And the word, both legally and what we throw around the office, is zealous advocacy. And that's what you have to do. You have to do that because there's no appellate court that at least I know of that's going to lay back and say, you know what? He or she as a defense attorney tried and they were shut down and it didn't get on the record. No, the standard that most appellate courts have is we only hear what is on the record and we can only judge that. And if it's, like you said, either orally done at the time, and if you're getting shut down, you put it in writing, but that needs to be a part of the record.
Yeah, I agree. And, you know, there's been some fascinating rulings with this. We've been talking about the manner in which this court does. That's why I love being here at the Law&Crime Network, because you get to see it from all across the country, the different ways judges do things, the different ways lawyers do things. Anyway, in this particular case, Brian, 3 years later, over 3 years later, a motorcyclist is just tooling around, if you will, in the desert and comes upon skeletal remains. That's what breaks this case. Up until this point in time, it was only considered a quote-unquote missing persons case. They thought law enforcement thought the family had gone to Mexico. But this motorcyclist is about to break the case. John Bluth, or B-L-U-T-H. Let's take a listen to his testimony, and we'll come back on the other end.
How you handled that bone, if at all, when you discovered it or after you discovered it?
I believe I turned it over with the stick.
Okay. Did you recall ever touching it, manipulating it, picking it up, throwing it?
No.
Did you meet with law enforcement at the dump gate entrance?
Yes.
What happened after that?
He followed me over to. I had a long piece of a bush that I had placed so I can remember where it was. And he followed me to there, and I walked it in.
Him being a deputy?
Yes.
After that, were you involved in this anymore? Did you do anything else?
No, we walked in there, walked up and down the little rivulet, and then we went back to his car, and he called the forensic team because he wasn't sure too. And then we talked for a bit, and then he let me go.
Okay. You used a word, I don't know if I missed it or I didn't understand what you said, a rivulet?
Yeah, a little, like a channel where water goes through.
Okay.
A river, but you can tell water was going down a little. There's like hills.
Okay.
And this was a low point where that was.
What you believe was a human skull, you did not touch it?
No, not with my hand.
And when you found the human skull, you described you were in a rivulet. Is that right?
Can I object that he said one question and we're on two?
My apologies.
Well, I don't think it's not on a map, but just a contour of the land where it's a low point where water would go through.
And what were the weather conditions when you found what you believed was a human skull?
November-ish, probably cloudy, cold, windy probably a little bit.
And what were the ground conditions when you found it?
Dry.
Well, welcome back. That's John Bluth, who is the person that was on the motorcycle, found the skeletal remains in the desert while riding his motorcycle. Brian, not necessarily the most important witness in terms of proving a case beyond a reasonable doubt, but nevertheless, a powerful witness in front of the jury viscerally as they're watching that ultimately this is where the final resting place of this entire family was. And he's the guy essentially that cracked the case.
Absolutely. As a prosecutor, this is a great person that you can have on the stand to kind of give that emotional first reaction that a lay person would have when they see these remains. How callous the person who might have been discarding these people's bodies were. As a defense attorney, especially if you're going on the angle of, hey, this is a horrible thing that happened, but it's not my client, you might not want to touch into a lot of what he's talking about. You might want to touch on, and I think the prosecutor might have mentioned, did you touch the remains, or did you alter anything in any kind of way that might have disrupted the investigation? That's probably one of the few areas that I would touch on as a defense attorney here.
Then you make a very good point, because I have tried cases as a prosecutor, homicide cases in particular, where I've seen defense lawyers really beat up and bludgeon the family members or, people that were really not necessary to the defense in the case because they felt that, let me attack every single aspect of the state's case. One in particular I can think of where they attacked a 10-year-old girl, watched her mother die, and the little girl's crying on the witness stand. You got to be shaking your head. You say, bad defense move there. She had nothing to really attack the defense of passion provocation.
Yeah. The first words out of my mouth if I was defending this case would I be like, sir, I am sorry for what you stumbled across. I wish that upon no one. But I'm going to have to ask you a few questions where you're going to relive this. It's just because I, as a defense attorney, have the utmost obligation to my client. And so may I ask these questions? And I would start off that way.
Well, it sounds to me like you're a believer that it's important for you to build a rapport with the jury to know that you're a good guy. And I agree with you 110%. That's why we have great guests like Brian on the show. We're going to go to a quick break. Don't go anywhere, please, because we'll be right back with more Law and Crime. Welcome back. As you know, in the McStay family murder case, Charles Merritt gave a very extensive interview to law enforcement that is being used during the course of this trial. Often is the time when people are trying to deflect responsibility. They will speak because they feel that they need to, otherwise the eye or the attention may go on to them. But Charles Merritt kind of knew from the beginning that they were kind of looking at him as a potential suspect. And let's not forget that Dan Kavanaugh plays a big role here. The defense wants to point the finger at Dan Kavanaugh as the person that also had a motive, that also had an interest in this, and that is the person that is truly responsible for this crime. Now, the judge has limited some of that testimony, but nevertheless, it's kind of bleeding into the case. So let's listen to Charles Merritt talking about Dan Kavanaugh.
I was building every waterfall all myself, and I was dying. That's what gave me a heart attack, actually. It was because we got really busy last year, and we were just really trying to. What's Dan's role? Dan was the one that he actually, to the best of my knowledge, he owns part of Earth-inspired products. Joseph was buying him off. Him and Joseph kind of weren't real happy together. Or Joseph wasn't real happy having to pay him so much. Do you know what he paid? I have no clue. Joseph didn't tell me a whole lot about it. Were you, Joe, and Dan all lived in the same apartment at one time at the beach? Oh, no, I've never met Dan. Oh, you've never met him? No, I've never met Dan. The first time I talked to Dan was a week ago or a little less, or when all of this started. Dan called me and said, "Hey, dude, what are we going to do?" I said, "I don't know. I don't have any access to, Joseph's emails. I don't have any access to any of this. I can't help him." That's the extent that I know about Dan. As far as my role, I met Joseph. He actually contacted me to start building custom waterfalls 2.5-3 years ago. And I started building his custom waterfalls, and I'm still doing it now, today. And so I don't have really anything to do with Earth-inspired products. I have my own, I manufacture waterfalls. I had my own line of waterfalls, my own, everything. Joseph got me more deeply into the custom ones. And he does all the sales. Basically, we're partners in getting waterfalls done, and we make money, but.
Okay, so we're listening to statements made by the police, by the defendant. I'm curious, in New York, how you think this would play out. I've been arguing that third-party guilt, that the defense saying that this was Dan Kavanaugh, if there's any potential relevance to that should be admitted as a potential alternate suspect in the case substantively, or to argue that the prosecution and the investigators didn't do the proper investigative work to rule out all other people, but they pointed the finger, which I'm telling you, Brian, I've been on crime scenes. I've seen right from the get-go. They say that's the person that did it, and everything else is discarded. Now, there were some salty text messages going back and forth. Dan Kavanaugh also took money out after the McStay family went missing, yet the judge substantially limited the amount of evidence that they could bring out in terms of pointing the finger towards him. Third-party guilt in New York, is it more lax there? Would you expect that this kind of information would be admitted?
I would expect it to be admitted, but I say that with hesitation because judges, at least where I practice, they're about as different as every sock you might have in your drawer. One judge might let it all in, one judge might not let it in at all, and one might find it in the middle. Sometimes you got to forum shop a little to get what you want. In the cases that I've done, we've actually done this before, where you say, hey, it's a part of the investigation. I can show the lack of investigations by the detective and why it led them to the wrong person. Or you can keep it, as you said, in the theory of, if this is motivated by X, let me show you all the different people who had the same motivation, and then bringing that beyond a reasonable doubt.
Yeah, because we all know that there's investigative bias and confirmation bias, and just to the basics of human nature itself. And it definitely happens in investigative and prosecutorial work as well. Prosecutors and cops aren't impervious to the foibles of human nature. So even at a minimum, by saying to the cop, you excluded this piece of evidence with regard to Dan Kavanaugh, or this or that or the other thing, may not be that Dan Kavanaugh did it. And I don't mean to suggest that the man did. He's not charged with any kind of crime. But what it does show is that you're sloppy in how you come to your conclusions. And if you're sloppy with respect to having disregarded all this, maybe you disregarded something else, no?
Exactly. I think that the strongest way I've seen it put is that, Your Honor, at the end of the day, you will tell the jury that they're allowed to consider both the evidence and the lack thereof. I'm exploring the lack thereof and the purpose for that. And the jury has every right to hear that so they can make the determination that my client is innocent.
Yeah, because you're bringing up a very important point. At the end of a case, the jury has read a jury charge, what the law is, and the judge says you can find somebody not guilty for a lack of evidence as much as you can find somebody guilty for evidence. So that's really, really important there. Yeah. Listen, the cell phone tower hit that comes down by the desert of Charles Merritt, I have seen people that get involved in murder cases in disposal but weren't actually involved in the murder itself. If you were defending him, if that evidence is really solid from the phone company, would you be making that argument? He may have been there, but it doesn't necessarily mean he committed the murder?
For this case, maybe not. Because the proximity of being there and the motive might bring it too close for me to feel comfortable to make that argument. In other cases where there is not so much of a motive or the prosecution is not putting on such a strong case about the motive, I might, but I always err on the side of caution, and that seems a little difficult.
10 seconds or less, though. How do you get around the cell tower records then?
It's only approximate location.
Yeah,
it's not exact.
It's going to be rough because it's a long way from where they are. But I hear your point, definitely. Hey, guys, listen, it has been great being with you here. Unfortunately, I have to go. My time has ended. I will be back Wednesday at 12:30 to 4 o'clock. If you get a chance, go to RBianchi ESQ on Twitter. Law&Crime Network, gavel-to-gavel coverage. You can't get any better than this network. Stay tuned.
You're watching the Law&Crime Network's live coverage of the McStay family murder case out of Southern California. I'm here with attorney Brian Buckmire. So, Brian, we've got the medical examiner back up there talking about more than one impact causing that much injury and just how much injury was caused, I say injury, but how much damage was caused to the skeleton in the process of it being buried and then kicked around in the desert.
Yeah, and it's interesting how the prosecutor is trying to highlight that this damage could have happened in the location that they're suggesting without serious blood loss or serious blood flow. I think that it's going to be a very interesting cross-examination. I saw on the tail end there, they were trying to describe that some of these fractures and some of these breaks might have occurred post-humerus, so after the person was dead. I haven't researched this. I haven't really looked into this case in terms of the science behind it, but I'm pretty sure you can tell the difference between a skull falling apart and a hammer hitting it.
Yeah, we're going to take a quick break here. Now on Law&Crime, and be back with more live testimony when we resume. You're watching the Law&Crime Network's live coverage of the McStay family murder case out of Southern California. I'm here one last time with attorney Brian Buckmire. Brian, my colleague Linda Kenny Bodden, famed attorney, called this one on Twitter, folks. If you're not following her, you have to, because she said this medical examiner is probably going to get up there and say all these wounds could have been caused without a lot of blood loss. That, under the prosecution's theory, explains why there was not blood in the home other than these suspected little tiny spots on the table that they're not even sure are really blood because they didn't notice them right away. And that's exactly what she said.
Exactly. And the prosecutor is definitely going to tie that very well together when it comes up to summation and explain why this fits their narrative, why it fits their story. I'm going to be very interested to see what the defense attorney steps up and says. I think the strongest thing you can do is try to cross-examine this person very carefully, but also try to mirror some of the language from the statute of where you are, of what beyond a reasonable doubt is. And when you start doing that, you can start asking questions, well, could it hypothetically be this? Could it maybe do this? Is it within a shadow of a doubt this? And then when you go back at summation, you remind the jury there is a standard here that the prosecution has to meet. And them saying maybe kind of sort of close enough isn't that standard. And then you reiterate what they said during cross-examination.
Look, and again, there's no clear evidence. This is all circumstantial, and little by little, one could say it's piling up, but there's no clear evidence pointing directly at the defendant himself. We're not sure he's the one that did this yet. the state has to continue to prove that. It's going to be a long trial. Brian Buckmire, appreciate your insight here on the Law and Crime Network today.
Thank you very much.
We're going to take a quick break here on Law and Crime. We'll be back with more of this riveting live testimony in the McStay murder case when we return again. It's coming bit by bit, but the prosecution making some important points about these forensic remains.